tell the children along with the father so that they were on the same page?
I didn't see that it was necessary to have a conversation with him about that. We don't talk about that with our children together. We don't do anything together. As far as communication, we do communicate. But when it comes to sporting events or anything like that, we separate and there's nothing talked about.
But you would testify that you made your children well aware of what was occurring in court.
To an age appropriate degree, yes.
And you would then also then say that you were receptive of your daughter sending you the photographs, correct?
Yes.
Okay. Is it your testimony that you did not ask her to make these photographs?
No, I did not.
Is it your testimony that you've never inquired upon her to take further photographs?
She has asked me what she should do, if she should take a picture, and I've replied yes. But other than that, I have not given any other authorization or advice to her on what she should do.
And again, in an attempt to co-parent, that did not happen. You did not make a communication with the father, correct?
As far as Shaylin taking pictures and sending them to me?
Yes, ma'am.
No, I did not.
With the alcohol that you say that you see in the photographs that came from Ms. Shaylin, according to your testimony, did you attempt to talk to the father about that?
No, I did not.
You're aware that your daughter has no issue with finding her father in trouble, correct?
What's the question?
You're aware that your daughter has no issue finding her father in trouble. She's pleased to show you these photographs.
It's not that she's pleased. She wants to make sure that he's doing what he's supposed to be doing.
Objection as to the formula. Sustain the objection.
Again, you've not declined the photographs and you've not spoken to the father about the photographs, correct? You are aware that you are to attempt to co-parent with the father, correct?
How am I supposed to co-parent with him regarding that when he is not doing what he's supposed to be doing?
Well, ma'am, I will get to ask the questions from here. You are aware that as part of your parenting plan, we talked about your parenting plan today, so we're going to bring that back up. The first thing in there is an attempt to co-parent. But you're stating today to the court that you've not made any communication with the father concerning this, correct?
Not about the photographs, no.
You also have said that your daughter is a rule follower. But you then testified to her having, at her father's house, been in trouble, I'm assuming, for not following his rules.
I don't know what goes on over there other than what they tell me.
Okay, what has she told you she's in trouble for then?
Lots of things.
Could you please enlighten us?
Being disrespectful to Jennifer.
Okay.
Having an attitude, having a smart mouth.
You feel in no way that affects her desire to then retaliate against her father?
The photographs have not necessarily been sent when she's in trouble.
Now, you've never been in Mr. Phelps' current home, correct? Okay. And these photographs that you have in your possession showing what alleges to be alcoholic beverages or cans, you've never physically seen those either, have you?
Just from the photographs.
Just from the photographs. So you never laid hands on any of the beverages? Okay. You're not aware of whether or not they were empty, potentially in a recycle bin?
No.
Now, are you aware of the fact that this court does not have an order for Mr. Phelps to be utilizing an interlock system?
He's court ordered by Robertson County.
Yes, ma'am. But my question is you're aware that that is not this court, correct?
Yes.
Now, in drafting a petition, you've got two petitions for contempt. And I went back through both of them. And we have constitutional rights. We have due process rights. We're supposed to know specifically what the allegations made against us and what are made against my client are. Are you aware of how many times the word allege occurs within your petition? If I may approach you.
You may.
I have started with the paragraph specifically, the allegation.
Okay.
There in that petition, the third of my file, and an allegation.
What was the question?
There anywhere else in that document? I'll get you the. There anywhere else in the document?
I mean, I don't know. You just have stars and
Yeah.
I don't understand what you're asking. Yes, I know I signed it. Yes, I've already looked at it. I've signed it. I don't know a specific number, but we wouldn't have put it in there if it wasn't against Mr. Felt.
I'll read for you a paragraph number 9 from your petition, which was issued with this court on March 3rd, 2026. Paragraph 9 states, petitioner would allege that on January 31st, 2026, the respondent again had an alcoholic beverage in the home during the time the party's minor child had scheduled residential time, as evidenced by the photograph attached hereto as Exhibit B. Do you understand that to be an allegation against Mr. Phelps for which he has to answer?
Yes,
Also, paragraph 11 of that document states, petitioner would allege that respondent's actions in having an alcoholic beverage at the residence where the respondent exercised his residential time with the children is in direct violation of this court's order and constitutes willful and deliberate contempt, criminal contempt of the orders of this court. That is a specific allegation. Now, to which order it is specifically stating is being violated, that is not written at this time either, is it?
it just says alleged.
And it also says just of the orders of this court, correct? It's not dealt with specificity.
It states clearly pursuant to that order of this honorable court, respondent filed one specifically restrained into doing activities of complete investigative or underline, highlight, or underline and bold in any way subjection minor children to any type of alcohol drinking restriction, including but not limited to his personal use for around another individual, including his current airborne from possession of any one subjection minor children to any type of
As far as your objection to a misstatement of the order, to sustain the objection.
Now, ma'am, I'm assuming you've been around Mr. Phelps. You've not seen him under the influence of alcohol, correct?
The only time I really see him is at drop off and at sports or a school event.
So you've not seen him under the influence of alcohol, correct? Your children have not told you that he's under the influence of alcohol, correct?
That's not true.
So they have told you that he is under the influence of alcohol. Please tell me about when that occurred.
They have assumed that he has been drinking based off of his behavior.
Please, with specific detail, elaborate upon when they made such assumption.
I don't have dates or times.
Would it shock you if they were to have testified that they have not seen their father under alcohol, under the influence of alcohol?
sustain the objection. I think that the children's testimony was they had not seen him under the influence or drinking alcohol since the driving under the influence, or was it the,
Since
they
the,
indicated that it was since those photographs were taken, they had not seen him under the influence.
Your Honor, it was my understanding that the daughter stated that since the order where he wasn't to drink, she has not seen him under that.
I think
And that the prior order was that he was allowed to drink, not to excess.
I'll note that.
Your Honor, I have nothing further.
Please, Rick.
Do you, again, counsel asked you about co-parenting with Mr. Phelps. What happens if you try to have a conversation with him?
There has been some instances where I gave him documentation of dental work, or I've texted him and there's been no response.
If I could, shortly after we were in court on December 5th, did you have an opportunity to meet him somewhere to pick up the children?
We always meet at a specific location on Fridays at 6 p.m.
And again, you have a video that I was going to, somehow my computer, the internet, I can't download it to do it on the internet, but I'm going to just play the audio. Did you record a conversation that transpired between you and him when you were trying to discuss him driving with the children?
Yes.
If I could.
I can too. You're not supposed to be driving this vehicle. No, you cannot. Is there a breathalyzer in it? Why? You are not supposed to be driving a vehicle that does not have a breathalyzer in it. I will, because you are violating. Yes, you are. Okay. Love you.
Did you attempt shortly after we were in court to not have him drive with your children?
Yes.
Did he become angry and agitated? And that illustrated the conversation. Is that correct? Again, begs the question, do you have to treat him like a child and spoon him the rules on what he's supposed to do? Your Honor, again, it comes up to the situation. Your Honor has to determine whether or not the defendant's actions were willful. Counsel has raised the issue by saying that this woman has an obligation to, quote unquote, using the words co-parent, to talk to him and explain to him what he can and can't do with the children. So that's the basis of my question, is it was raised on cross-examination saying that she has some obligation in the terms of co-parenting to tell him what the order says.
Has nothing.
none of which has any relevance to the question of whether or not this defendant, who is on trial for criminal contempt, did or did not willfully violate a court order.
I'll move
So
on, Your Honor.
it's not relevant. And if your objection had been as to the relevance, I would have sustained it, but otherwise it's overruled.
I'll move on, Your Honor. That's all.
Thank you, ma'am. You may step down. Ms. Roberts, do you have any other witnesses? Petitioner or plaintiff has rested their proof. Do you have any witnesses you wish to call?
For Rick Burton, there's not being different things that we've not been approved, it's not reason to help my client had anticipated for the court. It's my understanding in reading this here petition, the only way that I can deduce an allegation from the word petitioner alleged. He's alleging that he violated the most recent court order, and I would say that at this point in time, that he has been beyond.
Overruled your motion for judgment by acquittal. Court finds that there has been sufficient evidence introduced that would sustain a motion for judgment of acquittal. The question then arises as to whether or not you wish to throw in any proof.
Yes, Your Honor.
Call your first witness.
All of that.
Stand up, raise your right hand and face the clerk.
I do. Mr. Phelps, you understand why you're here today?
Yes, sir.
All right. Do you recall being here previously?
Yes, sir.
You recall confessing to this court what it was that you felt at that point in time you were guilty of?
Yes, sir.
Do you recall the many conversations that we had after that court hearing?
Yes, sir.
Have you violated any of the court's orders since the moment in time we left this courthouse? I believe it was in November, Council, in November of 2025.
No, sir, I have not.
Do you consume alcohol in the presence of your children?
No, sir.
Do you keep alcohol in the presence of your children?
No, sir.
Are you full well aware of what the court's order is pertaining to alcohol in your children?
Yes, sir.
Are you currently abiding by all of the, I'm sorry, Your Honor, I'm losing my word, all the terms of your agreement with the criminal court out of Robertson County as it pertains to your DUI?
Yes, sir.
All right. Do you currently have the proper insurances, interlocks, and everything that is necessary in order to commute?
Yes, sir.
And your statement today is that you don't have alcohol around these children. You do not violate this court's order.
Everything's good. Yes, sir.
Do you feel that maybe sometimes things are done against you?
I've learned to believe that. Yes, sir.
Are you fearful that some things may be staged against you?
Saying the legal witness.
Is there anything that your daughter's doing that you're fearful may not be truthful?
Yes, sir. I mean, this is my freedom. I feel like my freedom's being played up, tossed around like a tennis ball, and I take that very serious. Serious.
You appeared nervous when we were in court last time. You appear to be not as nervous this time.
Yes, sir.
Why is that?
I've no clue. I know I've done everything right. The
Maybe
right
is
way
that-
done what the court has told me to do.
Is that maybe why you're not as nervous this time? Because you feel in your heart?
Saying the legal witness.
Is that why you feel that way?
Yes, sir.
Because of your previous statement? It's because it's in your heart?
Court ordered me not to have it around kids, not in the house, being under the consumption of it when I had them kids. And that is what we've done. We have went out to Texas Roadhouse. We do go out and eat. But
You're stating that because there's alcohol in a restaurant?
yes, other than that, that's all there around it. We don't partake in that. Not only do I not, Jennifer does not neither.
And who is Jennifer?
My girlfriend.
Live-in girlfriend?
Yes, sir.
When you say you do not partake in that, Clarify that statement for me, please.
We do not have no alcohol around. We do not consume alcohol. It's,
Now, do you consume alcohol when you do not have your children?
we do,
What's your parenting plan currently? Are you on a week off, week on?
Friday to Friday, yes, sir.
So there's an entire week that you have where you would state you do consume
We get
alcohol.
off, yes, sir.
But again, it's your testimony that never in front of your children does that occur.
Never do. I haven't since the last time we left.
Do you recycle?
Yes, sir, we do.
Okay, and in your recycling bin, what might one find?
Our beer cans,
Are there other, do y'all recycle other things?
Diet Mountain Dew, Dr. Pepper's, cans, cat food cans.
But you're a recycling household?
Yes,
Would it be safe to assume that one might find a beer can in your recycling bin at this
Yeah.
moment?
yes,
But that's not endangering your children or putting them in the presence of alcohol?
no, sir.
Those are my questions, John.
Mr. Roberts, you may cross-examine.
You think that she's just a vindictive, conniving something and just trying to get at you? Is that-
No, ma'am, I don't, but I know that since we left court last time, I have not done anything to jeopardize me seeing my kids going through that. I don't know where she has come up with the picture. The one of me driving, I do. The ones with the, I did. I did.
Okay, you have, and you have a broken car. It does not have.
I was uneducated on that.
You drove there. You put the children in the car, or they got in the car. She told you you're not supposed to drive,
Yes, ma'am.
and you yelled back, "I got papers."
I didn't know.
No, you said, you want me to play that back?
No, ma'am, no, ma'am.
You said you have papers. And you did not, did you?
But I didn't think that it said on the papers that I couldn't drive nothing but that. And I did get that clarified up right after that. And that was, I think, around January, somewhere around my birthday.
How did you get it clarified? Go to your probation officer?
Yeah, I called her, yes, ma'am. And it has not happened since.
You understand you signed documents in court in Robertson County saying what the terms and conditions. Your Honor, it goes to the first allegation of contempt with
Well,
alleged.
Number one, it is the first allegation of contempt, but are you talking about the fact that he was convicted of DUI?
Yes, sir. And the reason I'm asking this question is he is saying he did not know that he was not to be able to drive. So when it goes to the terms and conditions of complying with a court order, then I'm bringing it up.
What's the credibility?
Yes, Your Honor.
Overall,
So you went to, you have already testified in this court and you admitted in Robertson County that you operated a motor vehicle after consuming 8 to 9 alcoholic beverages, beers, I believe it was. And you had a blood test that registered 0.19.
Yes, ma'am.
Did you have an attorney over there?
Yes, ma'am.
So you were legally, who represented you over there?
Jeff Walker.
Okay, so Mr. Walker represented you, worked out a plea agreement, correct? And you've already admitted that you knew the terms and conditions of your parenting plan says you could not drink in excess with your children, correct? And you had your son with you, correct?
Yes.
And you drove. So you were in the lake, in the swimming hole, wherever it was, drinking alcohol with your son.
Yes, ma'am.
You were the adult there responsible for him,
Yes, ma'am.
and you elected to put him in the car and drive with him.
Right.
Do you understand, or were you told that your son testified that you were straying off the road, you were messing with the radio, and he had to tell you to pay attention to drive?
Yes, ma'am.
And that was a true statement that he made, didn't you?
Yes, ma'am.
And the police came back and pulled you over,
Yes, ma'am.
allowed you with courtesy to call somebody to come pick up your son, and that was your girlfriend.
He called.
Well,
I didn't tell him.
so your daughter came to the scene where you were pulled over and your son was there in the car. And you keep saying you did nothing wrong. Do you understand you could have killed your son?
I know that. Yes, ma'am. That
Then
was,
why did you do it?
I have learned from that.
You've learned from that,
Yes,
okay?
yes, ma'am.
Put a pin in that. We're gonna come back to it in just a minute. So you went to court, accepted responsibility for your actions, and were placed on probation.
Yes, ma'am.
The terms and conditions of your probation were explained to you, correct? You met with a probation officer.
Yes, ma'am.
There was a sheet of paper that you were supposed to click off. And she explained it to you. It's a female, correct?
Yes, ma'am.
And you went over it, said you explained it and signed it.
Yes, ma'am.
And one of those was you couldn't drive. You had to operate a car with an interlock device on it, correct?
I can't remember that part, but yes, ma'am.
Well, you said you didn't remember it until she told you, and you said you had papers, then you called and checked.
I didn't have papers.
But you told her you had papers,
I was going by the ones that I got from the judge.
the ones that you got from the judge.
And it, yes, ma'am, that day we left for my DUI.
Okay. And you understand if I could approach. Is this what you're trying to do, what you got from the judge? This is the judgment sheet signed by the judge.
Yes, ma'am.
And this is what you're going out for, you yelling for, I think that I can drive this car.
Yes, ma'am. I thought it was something there.
Well, no, it says your license is suspended. See that little check mark right there? So where on there did it say that?
I don't understand the suspended because
You don't
they
understand
went
what,
straight to restricted. I went straight and got them with me.
so the reason I handed you that is because I asked about that you told your ex-wife that you had papers. And then you said you got it from the judge. That's the judge's judgment. So where on there says that you can,
Let me clarify what I was saying as far as that. I didn't know that I couldn't drive no other vehicle. I thought I just had to get the interlock put on my truck. That's what I was,
DUI, you just get the interlock put on and you can drive whatever you want to.
with all due respect, ma'am, that was my first and last one. I was new at it.
But that's what your understanding
I know
is.
now. Yes, ma'am.
Okay. And nobody explained in court to you that you were violating a court order by doing that.
Not that time, no, ma'am.
But you understand you violated this court's order by getting drunk with your kid. If you hadn't even driven, you had not got in the car, you called your girlfriend and picked it up. You got drunk at the swimming hole with your then 13-year-old son,
Yes,
didn't
ma'am.
you?
Yes, ma'am, I understand.
And you knew, did you not, that that was a prohibition that was issued by this court
Yes, ma'am.
in January of 2024?
Yes, yes, ma'am.
And you ultimately disregarded and said, "Psh, whatever, I'm going to do what I want to do." Because you sat in that witness chair on November 5th and said, I'm an adult, I can drink. Didn't you?
Ma'am.
And you have elected to continue to do that.
No, when I do not have kids.
I didn't ask, I didn't put a qualifier. You continue to drink.
Yes,
Because you talked earlier when I said put a pin in it, I've learned my lesson. You also understand on November 5th, you were sitting in court, sitting in that chair right there when this court gave a ruling, weren't you?
yes, ma'am.
And you heard directly from this judge saying, you are not going to even have alcoholic beverage in the house.
Yes, ma'am.
And you have had alcoholic beverage in your home after that date. Isn't that correct?
I don't recall it being in that day. Yes, ma'am, but not when I have kids.
So your daughters broke in your house and taken pictures?
I don't know where they come from.
Yeah. Oh, there they are. You forget your words and I lose the picture. All righty. Your Honor, may I approach?
You may.
And I realized we had your children.
She's been into wars in this church house. And there's a twisted T. See that?
That's T.
Twisted T, you know.
That's Twisted T, yes, ma'am.
And she's been in the closet, and there's a case of twisted T.
I see a case of Twisted T.
And then she took a picture of the refrigerator, and there's some, not much of, beer. What's that? What kind of beer is that?
It looks to be Michelob.
Big fun.
Yes, ma'am.
And that was in your house with your child, in your dogs.
I don't know that. It wasn't, it shouldn't have been, no, ma'am. It wasn't when she was with me.
You said your daughter, being back to the big decline.
I don't know where them pictures come from. No, ma'am.
Daughter also provided pictures of Nicholas two office, in the laundry room where y'all recycle.
Yes, ma'am.
Right. And the day we took it, my contest about today, there's a twisted tea sitting in the cup holder of the girl for his finger. To make sure you pull that out.
No, ma'am.
You understood that you cannot have alcohol in your house.
No.
And that's because you made what could have been a fatal, irreversible mistake of driving drunk with your child.
Yes, ma'am.
You understand our children do as we do, not as we say a lot of times?
Yes, ma'am.
So, if your children go up and see daddy drinking all the time and doing that, what do you think they're going to do?
When they get older.
Same thing. But you have learned your lesson, but you're still going to drink, even though the effect it has on your children, seeing their father punished. You drink when they're not there.
My kids, no, ma'am. When I have them, no, ma'am.
But you understand, your daughter testified that these were in your house when she was there during your residential time.
Okay.
That she took them and immediately and texted them to her mother. And her mother testified as to the date and when that was done. It was residential time. Can you dispute what your daughter said and what your ex-wife said?
No, ma'am. I know there is none in our house.
Right now,
Right now, I've got the kids this week. Right now, there is not.
there's nothing in your refrigerator.
No, ma'am.
Okay.
You heard this statement, then the twisted tea picture is February 2nd, you have it, don't speak of it.
I'd have to look at that's a calendar. And it could say here, the kids, I had them.
January 11th, twisted tea in the back. January 1st, beer in the refrigerator. November 23rd, twisted tea in the cup holder where you drive it with beer. And again. So that's right there it is. 1, 2. 3 occasions that your daughter has found alcoholic beverage. You suggested them with alcohol with a call of people. But
I have not had no alcohol since the last time since the last time we were in here in November. I have not had none at the house.
Okay, well, and I want you to qualify because your statement was, I've had no alcohol since we were here November 5th. And then you,
I have on the weeks that I do not have the kids, I do.
and how often do you drink?
It ain't daily. Might have a couple of beers. It ain't really and a set amount. It ain't nothing like it used to. I've learned so much over the last year.
When your son testified, he testified about your daughter being upset because she got whipped. And I asked your son about why would she got whipped. It says back talking, I think is what she said, smart mouth or back talking. And you punish her when she doesn't obey your rules.
Yes, ma'am.
And you're perfectly capable of obeying the rules of this court,
Yes, ma'am.
including not driving, not drinking to excess with your children, and at the beginning, and now not drinking at all, but also not possessing it or subjecting them to it in any way. You understand that? And you're capable of doing it.
Yes, ma'am.
And if you take your daughter's testimony and your ex-wife's testimony that corroborated her testimony is true, you violated this court's order on 4 occasions, haven't you?
I don't see that being true.
Well, you agree that you violated the court order by getting drunk and with your kid.
Yes, ma'am.
And then the 3 photographs that we have submitted are, if the judge finds those to be credible, that would be 3 other violations, correct?
Yes, ma'am.
So that's where I got my 4. And you're capable of understanding. You knew you weren't supposed to do it. And your testimony here is that, well, I just can't, I don't know. I don't know where the pictures were taken. Right?
I don't know where them pictures are taken.
Why do you think your daughter's out to get you?
I don't know if she is out to get me. I know she,
And again, I don't, attorneys say things in representation, and I just want to make sure and clarify that when this comes out, the questioning that he did with my client, you understood it was that Shaylin is out to get you.
Shaylin loves her mom. I know she loves me, without a doubt. I love my son loves me, my son loves his mama. Yes, ma'am.
That's all.
Where do you have redirect? Thank you, sir. You may stand down. You have any other witnesses? Mr. Roberts, you have a rebuttal proof?
No, Your Honor.
I'll hear you in argument.
I'm late.
Your Honor, I'd like to say that, again, just as it pertains to due process, specificity, and perfected pleading, and understanding of exactly what it was that we were here today having alleged against us, it appears that the allegations are one allegation of alcohol in the home. Those are the only photographs. If these photographs existed prior, they could have simply been attached to the petition alleged as such. I have what appears to be a singular allegation against my client stating that on January 31st, he was found to have an alcoholic beverage in the home. That, Your Honor, I have nothing further other than the understanding of the effective pleading by client's due process.
Well, reading the petition for criminal contempt seems to me it makes very clear that it sets forth the fact that there was an order that was entered by this court on November the 5th. And that it set forth certain restrictions, but even before that, the valid parenting plan that was entered in this court clearly indicated that there was to be no consumption of alcohol specifically by Mr. Phelps. That was an agreement he agreed to, and the language of that parenting plan said that he should not consume alcohol to excess. In the petition for criminal contempt, it goes forth to say that he had violated that order, as he's admitted, by getting arrested for driving under the influence after having consumed 8 to 9 beers and driving the vehicle at 0.19, and that he had their minor son with him while he was doing that, and that he knew he had violated the restrictions on the parenting plan when he did that. Then I put an order down that was pretty specific. You know why? Because, Mr. Phelps, I thought you were a good father, and I felt like it was a good, I think it's important for these children to have both parents in their lives. I think your children love you, whether or not they approve of what you do or not. I think your children both love you. There are certain kinds of cases that I absolutely hate to hear. This is one of them. I hate to hear cases where I have to have children. You have two good-looking children, two fine children. But we've just put those children through a ringer. Emotionally, I've had to, I mean, you know, it is unfair to your children. And why is that? Why are we here today? Why are your children having to go back there and testify and cry in front of strangers like me about the situation? Why is that necessary? Only one reason it's necessary, and that is you're choosing alcohol over your children if you continue to do this. I understand you're a grown man. I understand you can drink anything you want to. You can drink yourself into an early grave as far as this court is concerned, and there's not much I can do about it. But I can control what you do around your children. And so when we were here in March, I tried to ensure that you would continue to have this equal division of time with your children, that you would continue to have an environment where that, you know, you and your children could be together and they would feel safe and that she would be satisfied that there wouldn't be any problems. So I put that order down, and the order is not hard to understand. The order says the following. It is ordered, adjudged, and decreed that the respondent, Brian Keith Phelps, shall remain, and I think that's a topographical, it says his schedule shall remain as set forth in a permanent parenting plan, but he is specifically restrained, enjoined, and prohibited from consuming, possessing in any way, or subjecting the party's minor children to any type of alcohol during his residential time, including but not limited to his own personal use, or allowing any other individual, including his current paramour, from consuming, possessing, or in any other way, subjecting the minor children to any type of alcohol. Now, you could make the argument, well, that doesn't keep me from having alcohol in the house. I just don't need to open it in front of them. Except for the next paragraph. It is ordered, adjudged, and decreed that there will be no alcoholic beverages at the home where the respondent is exercising his residential time. Now, why is that? Why did I do that? Because when you think about it, your son's already been through a traumatic experience. He watched his father get arrested. That's just something that doesn't sit well with this court, that would have to be the case. And I would have thought that out of consideration for the children, you might have thought more about the fact that knowing that your son was with you and your daughter, I think, came back to the scene and picked him up. And so they got to see their father being arrested because he was drunk on his butt. That is not one of your finest moments. And I would have thought maybe that would imprint itself enough upon you that you would not want to have alcohol in your house under any circumstances when they're there. Why? Because they see the alcohol, it reminds them of what had happened. It also puts them in a position where they wonder, is dad drinking again? When they see it in it. Now, your daughter has taken pictures. I don't believe she broke into your house and took those pictures and surreptitiously did that. I think she took them when she was there because there was a box of beer in your refrigerator on the date that those photographs reflect. There was also alcohol cans there. And I don't know whether they were full or cold or hot or empty or what, but they're there. And that reflects the fact that you have little regard for this court's order. Why did I allow Ms. Roberts to go on a tangent about whether or not you drove this car with an interlock device or not? I'm sure you wondered why that happened. Because it reflects whether or not you are, number one, credible. And I don't find it to be credible that you thought you could get behind the wheel of any other car as long as it wasn't that interlock device car, and that you could drive any other car you wanted to. And that you just found out a few days after that. I think you thought you could get away with driving without having to do the interlock, and that was the reason you were doing it. So that's one reason, your credibility. The other reason is because it reflects whether or not you obey rules, whether or not you're willing to obey rules. And as a result of this situation, I'm now forced to have to make a decision. This is not your children's fault. This is only one person's fault, and that is yours. No one forced you to get behind the wheel of the car when you got arrested for DUI in violation of that court order. No one forced you to have these beer cans and alcohol present in your house. I find by the credible proof in this court that you have violated this court's orders on 4 different occasions, or 3 different occasions, because the photograph of the can of beer in the vehicle was taken, according to my understanding, on a date that was before the last order went down, which was entered in December of 2025, that order, that photograph of the beer can was November the 23rd, so therefore it predated the entry of the order. So I found that instead of 4 allegations, I found that this plaintiff's proof has sustained and proven beyond a reasonable doubt that the defendant willfully violated the orders of the court on 3 different occasions. And each of those occasions, I ordered that he be sentenced to 10 days in the county jail. Under the law, I can sentence those consecutively, and I'm going to do that. So you're going to have a 30-day sentence hanging over your head. Now, I'm not going to require you to serve any part of that right now. You know why? Turn around and look over your right shoulder. See those 2 people sitting back there, and those 2 children? They had to come to court today and testify about things that were very unpleasant about their father. They love you. They cried too. So you go ahead and cry all you want to. But the fact of the matter is that they're not the blame. They're not the fault in this situation. So you've got a choice to make from this point on. You can have alcohol anytime you want to, as long as it's not in violation of your probation. Frankly, you violated your probation by driving that vehicle without an interlock. And if your wife really wanted to hammer you, she could report that your ex-wife, she could report that to the authorities in Montgomery County or Robertson County, wherever you're on probation, and you could very easily be charged with that. I hope that doesn't happen because it serves no purpose at this point. I think hopefully you've learned a lesson. So what I want you to understand is I'm sentencing you to 30 days, and I'm going to suspend that 30 days. But that's going to be hanging over your head to see whether or not you comply with this court's order. Because it's something, and I don't expect that you're going to have another problem. But the other thing I want to tell you is that the 2 of you have these children, and you agreed to co-parent them. So right now you are still under that order. And you need to find a way to co-parent each other. You need to find a way to communicate and allow the two of you to be involved in your children's lives. Both of you may have moved on with other people, I don't know, but obviously Mr. Phelps has. But it is a situation where you need to think in every situation about what's best for your children. Your children love you. They want you to be happy. They want to be with you, but they want to be safe and not have to worry about whether or not you're violating a court order. So it is this court's order that the 30 days will be suspended, and that will conclude this hearing. So, anything else?
Not delay, it's suspended, it is suspended.
I'm sorry.
Again, his 30 days is suspended.
It is.
So future infractions, you're not reserving, I just want to make sure you're not reserving him spending additional 30 days for violence again.
If he violates the court's orders, he will serve this 30 days and any additional time that the court finds he's violating the court order. So this 30 days is suspended, and I'm suspending it and placing you on probation, so to speak, for this court, at least for the next year, for 11 months and 29 days, because it's going to misdemeanor.
So it's appropriate when I put suspended pending his future.
That would be appropriate.
Okay, thank you.
So you've got a decision to make on whether or not you want to have alcohol in your home when your children are there, or whatever. You can do whatever you want to do, but the main thing I also want is to make sure that these children are not punished because they came to court. So love your children. Don't punish them for this. They've been through enough as it is. So, all right. That will conclude this hearing. Ms. Roberts will draw the orders.
Your Honor, may I request also a strict prohibition from discussing the children's testimony or punishing them in any way
Well, it says that, but I will say that
I mean,
if I find that anyone has punished either one of these children for the testimony that they have offered, or even harshly administrator of this estate, Ms. Brady is an attorney in good standing with this court. She practices in front of this court on a regular basis. She's very good at what she does, and I'm going to appoint her as the independent administrator of this case. And Administrator ad litem, I think, is what we would be referring it to. So, Ms. Brady, if you will draw an order, and Mr. Jeffrey Stewart's address is set forth in the file where he's incarcerated, and Mr. Christopher Stewart, if you'll speak with Ms. Brady and give her your residence address so that she can mail you a copy of all the proceedings. Mr. Stewart, Jeffrey Stewart, I have granted your request to appoint an independent administrator. Margaret Brady has been appointed here. She will communicate with you by mail.
Thank you, sir.
All right. Oh, one down.
They muted me and took me out.
Bill is in the hearing, but I don't know that they haven't turned on. You know if the jail is ready on Mr. Doris? Okay. Let me know when the jail is ready. Good morning.
Good morning, Your Honor.
Do you have Kenneth Mitchell, I'm sorry, James Doris there?
He is walking down the hallway now, sir.
All right, thank you. We have Tammy Doris versus James Doris. Ms. Brady Wilkerson.
Huh? Go ahead and have a seat for him.
All right.
Your Honor, this is James Doris.
All right. Are you James Doris?
Yes, sir.
All right, Mr. Doris, you're here today because there's been a motion for default filed in the divorce action that your wife has filed against you. And we are proceeding in that case, but you are entitled, even though you're incarcerated, to be aware of this proceeding. It alleges that you, on the motion for default, it alleges that you were served with process on November the 24th, 2025, while you were in the Cheatham County Jail, and that you have not filed any answer, either representing yourself or with any other means. And as a result of that, the plaintiff in the case has filed a motion for a default judgment, which under the rules they would be entitled to.
Well,
Do you
Judge, I
understand
have
all that?
I had that, I did file that, and I do have a copy of it.
Did you say you filed an answer?
Yes, sir. Two or 3 days after the judge told me.
There are two items that Mr. Doris did file. One is, motion to oppose divorce, want to amend my marriage, and request a copy of this sent back to him. And then he has a motion to compel that he filed, asking, that they be compelled to participate in marriage counseling. And so that's the only two things I've received a copy of. And I would ask the court to
I've got the copy. It says court.
not consider those an answer. Those were motions to request counseling, which obviously my client would oppose.
All right, let me address you, Mr. Doris, so that you understand where we are. On January the 23rd of 2026, you filed something that you styled an appeal. It's a handwritten document, and it states, I, James Doris, am hereby filing for an appeal over the motion for default and notice of final hearing over my divorce. I was not notified that I had to file anything until I was released from jail in February. I still have not obtained counsel on my behalf over this matter at this time. I am requesting to settle this matter after my incarceration. I do not agree to anything that has been asked of or been requested by the plaintiff. Please accept my appeal and allow me this time. All right, then you also filed on March the 6th of 2026, a motion to compel. The above style defendant, James Michael Doris, comes before this honorable court asking it to order marriage counseling to mend his marriage instead of ending it, and to do so through mediation of a professional, and also to appoint an attorney to Mr. Doris in this case as well. Then on March 13th, you filed a motion to oppose the divorce. I, James Michael Doris, wish to oppose my divorce. I want to mend my marriage through counseling. I need a copy sent to the judge over this case. I would like a copy sent back to me for my proof. Now, let me first address the request that the first document you filed, which was an appeal, a notice of an appeal. This court does not have the opportunity, does not have the power to compel you and Ms. Doris to settle your case. In other words, I cannot order that the two of you have to settle your case.
I still love my wife.
Pardon?
I still love my wife and my son very much.
We're gonna have to bring Mr. Doris into the courtroom. So just have Mr. Doris brought over as soon as we can bring him here. We'll proceed with this case. We're gonna bring you over into the courtroom since you're in the Cheatham jail. It's more difficult to hear from you when you're in the court, in the Zoom link. So we'll bring you over in just a minute.
Do what? What'd he say?
We'll get you brought up. Yes, Your Honor.
Down there. I think I gave my.
All right, let's try to see if we can get something simple. Moreland.
Your Honor, I'm standing on behalf of Ms. Jones, who's very sick today. She's asking the court to waive mediation and set this matter for final hearing.
There are two attorneys that show, Michael Durekowitz and Brandy Jones. And are they both in agreement to waive mediation? Do they have any reason why they want to waive mediation?
Well, just what she's put in here, the parties have made multiple attempts to reach resolution on this one limited issue and are likely to reach an impasse at mediation. Think they've made a partial asset distribution settlement and agreement, but they have the one issue of the equity from the proceeds of the sale of the marital residence they've been unable to resolve. So they don't believe that it'd be cost effective to go.
Well, I cannot waive mediation for one of the other judges, but I can waive it if necessary for
So in front of
myself.
yourself.
You'd be looking at November for the next time.
I will let her know that.
Do they want to obtain a date by contacting the clerk?
I assume so, Your Honor. She called me this morning and she was very sick. You could tell by phone, so.
I can relate.
I understand. I'll let her know, Your Honor, to reach out to the clerk about a date in front of Your Honor solely.
All right, thank you.
Thank you, Your Honor.
You tell it's going to be a good day when you can't even drink your water without spilling all this. Would be a drinking problem, would we consider that to be a judicial drinking problem? All right. A motion to withdraw. Good morning.
National Bar, that's my motion to withdraw. Mr. Guy is here. I don't believe there's any opposition to us withdrawing. We're withdrawing at his request.
All right. So the motion to withdraw is set forth based on the fact that Mr. Guy, you wish to, I'm sorry. Yes. Mr. John Guy, is that who you are?
Yes, sir.
But it's my understanding that you no longer wish to have this law firm represent you and you want to hire new counsel. Is that
Yes,
correct?
sir.
All right, well, I will grant you 30 days to retain new counsel.
Thank you, Your Honor.
Do I have to retain new counsel?
You don't have to, but if you don't, I'm gonna give you 30 days to retain counsel. You can either do that or not, but if you don't, then you're required to administer the estate yourself and file whatever's necessary to conclude it, okay? All right, you got 30 days to make that decision. Well, there's nothing to speak with. Basically, you're saying you know what needs to be done.
Right.
So you've got 30 days to either hire a lawyer or get that done yourself. Okay, all right.
Markham. Judge, this is a petition to probate the holographic will of Ophelia Underwood Brown. And before we get started on it, Judge, the original will was never filed. I've got that here that we just sent into the court. The copy file, she just produced the original today.
All right, and you have two independent, non-party witnesses, non-beneficiary witnesses to testify about their handwriting.
I'm sorry, Judge.
You have your witnesses lined up to testify that this is their handwriting?
Yeah, I filed the copies when I filed the petition to probate. That's the original we're tendering to be.
I understand, but to administer a holographic or handwritten will, you must verify, you have to have witnesses, two independent witnesses that are not beneficiaries.
I've got
Okay, that's fine. That's all I'm asking you. So who is your client? Who is your client?
Linda Markham,
All right.
or Tanya, I'm sorry, Tanya Stewart. She is the daughter of Linda Markham, who was the original designated executor of the will. She's deceased, as is the other beneficiary in the will.
All right. So the beneficiaries under this handwritten will are Linda Helen Markham and Margaret Elizabeth Brown. Is that correct?
Correct.
So as a result of that, does that then pass to your client, Miss Stewart? Would she be then the beneficiary of the will because her mother has passed, correct? And that's my point, so that we're clear. The statute is very clear that you cannot verify a handwritten will by the person who is going to take under that will. It has to be independent witnesses that would verify that the document is in the handwriting of the deceased and entirely the handwriting of the deceased. And Ms. Stewart is the daughter of one of the original beneficiaries, so she stands to be a beneficiary under the will. This has nothing to do with you, and please understand that I would be glad to do it, but the statute requires it to be independent. And the reason for that is because obviously you have a vested interest in trying to say that this is a valid will because you are a beneficiary to it. But an independent, we had one the other day that we had two people who verified the handwriting. Neither of them was taking under the will, but that's what is required. So, Mr. McNabb, I cannot verify this will or admit it to probate until you have those independent individuals that will be able.
With all due respect, Your Honor, the holographic statute doesn't require two independent witnesses. It says two witnesses.
What began as an ordinary day in court quickly turned into an emotional courtroom battle when an incarcerated husband begged the judge to save his marriage. James Doris appeared from jail as his wife's divorce case was called. He insisted that he had filed documents opposing the divorce and repeatedly asked the court to give their marriage one more chance. The judge carefully reviewed every motion James had submitted. One requested marriage counseling, another asked the court to appoint him an attorney, but the judge explained that the law simply didn't allow either request. In a calm but firm tone, the judge made it clear that a court cannot force two people to stay married if one spouse wants a divorce. He also explained that because this was a civil divorce case, not a criminal case, James was not entitled to a court-appointed lawyer. Then came the emotional testimony. James told the court that he still loved his wife, that he had built the family home with his own hands, paid the bills for years, and only wanted to go back home. Fighting through emotion, he pleaded for counseling instead of divorce, saying he believed the marriage could still be saved. But the testimony took a dramatic turn when James started talking about the criminal charges that had landed him in jail. The judge immediately stopped him. "I'm going to stop you right there." He warned James that anything he said under oath about his pending criminal case could be used against him by prosecutors. It was a powerful reminder that every word spoken in a courtroom can carry serious legal consequences. After hearing testimony from both sides, the judge found there was sufficient evidence to grant the divorce. However, he delayed the final ruling on the property division because more evidence was needed to determine the value of the marital home and whether it should be awarded as alimony or divided between the parties. As the hearing ended, James continued trying to speak, but the judge issued one final warning. You're going to get yourself in trouble if you keep talking. The hearing showed that while emotions can run high in court, judges must ultimately follow the law, not feelings. Do you think the judge made the right decision, or should James have been given another chance to save his marriage? Share your thoughts in the comments, and don't forget to like, subscribe, and turn on notifications for more real courtroom moments.